Hey folks, Mark Smith at the Four Boxes Diner here. Huge news. This is a potential U.S. Supreme Court case, and I'm not kidding. Today, the Third Circuit Court of Appeals, which sits over the states of New Jersey and Pennsylvania and Delaware, just agreed to hear En Banc, which means all of the judges, a case that you're familiar with because we covered it here on this channel called Range versus the Attorney General Merrick Garland. This was a challenge brought by a plaintiff who was a non-violent felon, arguing that under the Bruin standard in the Second Amendment, he should be entitled to his right to keep and bear arms because there was no historical analog in 1791 of someone who was not violent being denied their gun rights for life. The Third Circuit, in a three-judge panel, ruled 3-0 in a per curiam decision that he lost his gun rights for life because in 1791, if you were not virtuous, you lost your gun rights. So they came up with a standard of virtuousness, which we've talked about, which is really an absurd standard and not with historical precedent. However, I did tell you when we talked about the Range case that there was another theory involving nonviolent felons that said that the standard for denying people their gun rights for life was if they were dangerous, also known as the dangerousness standard, not to be confused with the virtuous standard. Now, the dangerous standard applied in 1791 arguably because if you were an Indian who had shown yourself dangerous to the colonists, or you were a Tory at war with the colonists, you were by definition dangerous to the American colonists or colonies, and you could lose your gun rights. We could deny you the right to keep and bear arms because you were on the other team, so to speak. So right now, the Range decision ruled against the Second Amendment in November of 2022. The Third Circuit has just agreed to hear the case en banc, which means almost certainly the Third Circuit has decided to overturn the panel decision. Now, there's a little curveball here, which is if you measure this by political party appointments of the Third Circuit, it is currently 7-6 in favor of the Republicans, 7-6, which would suggest that there's a party line vote on the Third Circuit that the Second Amendment should prevail. However, there's one senior judge, Judge Jane Roth, who was on the lower court panel, who's 87 years of age, and Jane Roth, whose husband was the Roth IRA famous senator, by the way, from Delaware, a Republican nominally. But anyway, Judge Roth was on a panel that ruled against the Second Amendment, so she is allowed, because she was on the lower court panel, to sit en banc, even though she's a senior judge. If it goes along her plus party line vote, that might mean it's a 7-7. But here's the key point. If the Third Circuit overturns the panel decision, it will have effectively struck down a federal statute saying that under the federal statute, 18 U.S.C. 922G, if you are a nonviolent felon, you still get your gun rights, which means that if the Biden administration and the Solicitor General's office were to seek a seek certiorari from the U.S. Supreme Court on the Range case, provided that the Second Amendment prevails, meaning the dangerousness standard prevails, then the odds of the Supreme Court hearing the Range case before the U.S. Supreme Court is, I would say, close to 100%, because the Solicitor General of the United States, which represents the Department of Justice in front of the U.S. Supreme Court, if they ask that a Supreme Court review take place of a federal statute that has been ruled unconstitutional, it's almost a 100% certainty that the Supreme Court will take that case, which means there's an excellent chance, if the panel decision is overturned and the Second Amendment prevails with the whole Court of Appeals for the Third Circuit, and I think that's likely, then if Biden takes an appeal, which I think would be likely, the U.S. Supreme Court would hear this Range case in about 18 months on the question of whether nonviolent felons can be denied their gun rights for life under the text, history, and tradition of the Second Amendment. And keep in mind that Judge Amy Coney Barrett, I think a major reason why she got on the Supreme Court was because of a decision she wrote in a case called Cantor versus Barr, which was a Seventh Circuit Court of Appeals case, where she found that nonviolent felons are entitled to their gun rights because there's no basis in history to take away gun rights from people that were not violent. Okay, hope you want to know about something here today. Sorry about I'm in a hotel room, so I'm traveling today, but I want to get this breaking news out to you. Hopefully you learned something, and hopefully you'll subscribe to the Four Boxes Diner channel, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.